what are the general defenses in tort? So when one sues another claiming that the person has violated his rights and therefore a tort has been committed, the defendant, you who is being sued, you have defenses which you can use, but they apply in different torts and they may differ. This means we determine tort on a case-to-case basis, case-by-case basis. So it's not a one-fits-all kind of a defense. It suits the current tort that the defendant is being given a chance to actually defend himself. Number one, we have Volenti and fit injuria. And this is that voluntary taking of a risk. You put yourself in harm's way. You have voluntarily exposed yourself to being hurt. We talk of football matches, we talk of cricket matches. And when that cricketer, the batsman hits a six and the ball hits you, you can't claim for compensation, either from the stadium authorities or the batsman, because when you took a seat, you accepted the risks while sitting in the stadium. So you voluntarily went to that game, knowing that this bat can fly and hit your head. This ball can, again, hit you. So when you are hurt, you cannot seek damages. And you sitting in that, this is where we find hotels and their parkings, and they state clearly that they will not be held liable for any damages. Parking is at your own risk. You have come, you have placed your own car in that, and you have paid for that parking. It's not free, but you have voluntarily chosen to come park your car at these, let's say in town. You have paid for parking. You have put your car somewhere. Let's even say in front of City Hall, and you have gone. So when you come back and find that your side mirrors have been stolen, City Hall, the county government of Nairobi will not double. You will not claim it from there. Despite you paying, and despite you assuming that the only thing they won't do is to clamp your car, but you have voluntarily placed you in that area. So when we talk of Volenti non-fit injuria, the most important thing is that the action is voluntary. You see, no one forces you to go watch a match in the stadium. You can as well watch it from home. So you voluntarily wake up and go. And you work with the informed consent that anything can happen. As we have given that example of parking, it's normally written parking at your own risk. You park at your own risk, even in these malls, in these, when you go to the mall, it's clearly written that parking is at your own risk. So anything that happens, they cannot be held liable. So two things will need to be established. The plaintiff knew or could have expected the risks involved in such a situation, and that the person agreed by a statement of fact to suffer the consequences of the risk without force or compulsion or threat. So in Kimji versus Tanga Mombasa Transport Company, the plaintiffs were personal representatives of a deceased who met his death while traveling as a passenger in the defendant's bus. The bus reached a place where the road was flooded and it was risky to cross. The driver was reluctant to continue the journey, but some of the passengers, including the deceased, insisted that the journey should be continued. The driver eventually yielded and continued with some of the passengers, including the deceased. The bus got drowned together with all those aboard it. The deceased dead body was found the following day, and the courts held that the plaintiff's action against the defendant could not be maintained because the deceased knew the risk involved and assumed it voluntarily. So the defense of Volenti and fit injuria rightly applied. The bus company could not be held liable because other passengers disembarked. This one who urged the driver to continue did so voluntarily, knowing that the driver had insisted the road is not good enough. Again, the viability of of the defense of Volenti and fit injuria depends on the circumstances of each case. Otherwise, the consenting partner does not necessarily give an open check for you to be negligent or to act in any manner that you so please. So in Haynes versus Howard, the defendant's servant left a van and horses unattended in a crowded street. A boy threw a stone at the horses and they bolted. They exposed a woman and some children nearby to grave danger. And the plaintiff, a police constable, managed to stop both horses, but he did so at a great risk and sustained severe injuries. In an action brought against him, the defendant pleaded Volenti, and it was held that the doctrine of assumption of risk did not apply because the plaintiff, in rescuing the persons in imminent danger, had acted under an emergency caused by the defendant's wrongful act. And it was immaterial that the persons to be saved were strangers. Therefore, the defendants were liable. So for this one, these owners of the horses could not claim that the police constable knew and voluntarily placed himself in danger. He acted out of an emergency, so the defendants were held liable. Another defense in court is that of an inevitable accident. We are not able to foresee circumstances, and despite reasonable care, there's nothing you could have done to foresee this. And when we say inevitable, it doesn't mean that the accident was bound to happen. Rather, it could not have been avoided despite reasonable care. So in Stanley versus Powell, the plaintiff was employed to carry cartridges for a shooting party. A member of the party fired at a peasant, but the bullet, after hitting a tree, rebounded into the plaintiff's eye. The plaintiff sued, but the defendant was not liable, as the plaintiff's injury resulted from an inevitable accident. It's not something we are foreseeing. You see, we normally pay insurance because that element accident happen when you're on the road and when you have a business, fires and all these things. But in this case, it's not something that can be foreseen. You see, in the normal course of business, in the normal course of that shooting, no one would have expected a ricochet bullet to hit the defendant, the plaintiff, in the eye. And those cartridges, they're normally kept safely. It was not intentional. It's not something that anyone could have done anything to prevent it from happening. The third defense in tort is an act of God. The difference between the act of God and an inevitable accident is natural circumstances. And this injury, for it to qualify under an act of God, the natural forces must be unforeseen and the effects must be unavoidable. So when a storm is taking place, if one can take precaution and avoid the damage, the defense cannot be used. We talk about hurricanes, and They're acts of God, but warnings are normally given that there is an alert that that hurricane may hit that particular land, so evacuate. You therefore cannot sue if it actually hits. At times they pass because it's something natural. No one has any control over it. Or case in point in our locality, these mudslides that happen and landslides, if a warning is given and the inhabitants are told move to higher ground because this may happen, we don't have any control of over how it may happen, and it may actually not happen because, again, as you have said, they're natural, they're not man-made. So any damage that is suffered in such a circumstance, you cannot hold one liable, because if reasonable care has been taken, nothing else can be done. In the case of Nichols versus Marsland, the defendant had a number of artificial lakes on his land, and an unprecedented rain, such as had never been seen witnessed, caused the banks of the lakes to burst, and the escaping water carried away 4 bridges belonging to the plaintiff. So it was held that the bridges were swept by an act of God. The defendant was not liable. It was not his artificial lakes that carried the bridges. That rain, he had no control over the rain or the magnitude of that rain. We also have self-defense as a general defense in tort. And in this, where if someone injures someone or something that belongs to someone else while defending themselves or their own property, you can be excused if the force is reasonable. What cannot be excused is unreasonable force. That is, if someone punches you on the stomach, ideally you block the punch or punch him back. But when you go to get your gun and shoot him, that is excessive use of force. That is not even necessary. It's bringing a gun to a knife fight. It's not allowed. And for self-defense to actually work, you must prove that the defendant was under threat or under attack, and the defense, it must be for self-defense, not for revenge. As we've said, if someone punches you today, then you wait for them 2 days after and punch them, you cannot prove self-defense. It's something that is spontaneous. You've been hit, so you hit back. And it must be proportional to the attack or threat. We've talked of bringing guns to knife fights. It's proportional. If someone is punching you, punch them back. Don't go looking for knives to come harm them. And the principle is that the law will not hold you responsible for an action that you performed in order to save yourself or protect yourself. And where it was not necessary to use force, the law will not again protect you. So in Cresswell versus Sal, a dog owned by the plaintiff attacked during the night some lamb owned by S. The dog had just stopped worrying the sheep and started towards S, who shot it when it was 40 yards away. C stood for trespass to goods, that is his dog. And the courts held that S was justified in shooting the dog if 1, it was actually attacking the sheep, or 2, if he left the dog alone, it would renew the attack on them, and shooting was the only practical and reasonable way of preventing revival. So the onus of justifying the trespass lay on the defendant. An occupier of property may also defend his property where his interest is wrongfully interfered with. Again, reasonable force. So a trespasser in your land, you eject them using reasonable force. You do not go and get and probably cause more harm than necessary. So in that case of Cresswell versus Sal, if the defendant could show that that dog that he shot was actually attacking the sheep, or leaving the dog go, it would mean the dog will come back and harass the same sheep, then the defense would stand. If not, it can't be a defense anymore. So the other defense is that of a mistake. And it's usually not a defense, because it's not good enough to say you didn't know you were doing something wrong. But it can be used in case of malicious prosecution. And this is where you feel probably you've been taken to court and you're able to show that this prosecutor or the ruling is made against you either because of your gender, your ethnicity, your Christian beliefs. Someone is acting with malice. They're not acting on the facts laid out. They're not acting as per the rule of law. They have picked on something that they feel they can use against you and they run with it. We also talk of necessity. An act you did was necessary in the circumstances. Let's say there's a fire going on in your house and you don't have water, but your neighbor has that artificial lake we were talking about. So you're justified to enter his land without permission to fetch water to put out the fire. You don't normally go jumping over fences, but the act of the fire necessitated you to enter into someone else's property without their approval. And the level of necessity should be very, very high, so that the wrong done is smaller in comparison to the one rightfully done. Putting out a fire that can spread even to this neighbor is more important than you jumping over his fence to fetch the water. So we have Cop versus Sharp. And in this case, the defendant committed certain acts of trespass on the plaintiff's land in order to prevent fire, as you've said, from spreading to his master's land. The fire never caused the damage and would not have done so if the defendant had not taken the precautions. But the danger of the fire spreading was real and imminent. So it was held that the defendant was not liable, as the risk to his master's property was real, and a reasonable person is in position would have done what the defendant did. And this is where we also say someone without any association with you or your neighbor, if he sees a fire, it would also be the reasonable thing to do. There's a lake there, there's fire there. You jump into you enter into this person's land, fetch water to put out the fire. So this element of necessity is back to back with what would a reasonable person have done. Is it necessary for you to enter someone's land? If yes, is that what a reasonable person would have done? So there's also a defense where someone acts under statutory authority. For example, these railway lines that we have, the noise that comes from, probably if you live in Syokimau and the SGR, when it arrives at the station and all the noise that accompanies it, you have no remedy to that, because the construction and the use of the railway is authorized under statute. And the fact that they give the timings of the trains is them acting in a reasonable manner. You cannot stop a railway line from operating because it's noisy. You cannot tell them, no, when you're coming to pick your passengers or your goods, do so in silence. They're authorized by law to have that railway line there, and they'll continue to do so. So we have Vaughan versus Taff Vale Railway Company, And a railway company was authorized by statute to run a railway which traversed the plaintiff's land. Sparks from the engine set fire to the plaintiff's woods. So in this case, the railway company was not liable. It had taken all known care to prevent emission of sparks, and the running of locomotives was statutorily authorized. So because they have taken their due care, whatever happens after that, they cannot be held liable. They are allowed to operate these railway lines, and part of the dangers that are associated with them is that they may derail, they may fall in your land, but you don't sue. You cannot sue. They've not gone against what the statute authorizes them to do. In short, we have the capacity to sue or be sued. We had talked about when we were learning about administrative law, and we asked, can the government be held liable? So in tort, in Government Proceedings Act, the government is subject to liabilities in tort as if it were a private person, where the government, the respect of acts committed by its servants, breach of duties, and it's also liable for statutory torts. But it's not liable for acts done by members of public corporations like the boards that we have, maize and produce boards, the councils that are brought about. It's not liable for that. Infants and minors is that minority has no defense in tort. Infants and minors can be sued. But in instances where the intention, the malice or negligence is to be determined, an infant will be excused because they have not reached the mental stage where they know they're acting in bad faith. So that will be the basis of that. So the position of husbands and wives is covered by the Married Women's Property Act, and a married woman is liable in tort and may sue or be sued in the same way as if she was single. That is an unmarried woman. So the heads of states and diplomats, they're immune from the jurisdiction of the local courts. And the immunity is provided in the Vienna Convention of Diplomatic Relations and that Privileges and Immunities Act. So they enjoy immunity from civil and administrative jurisdiction of local courts. But this immunity does not extend to Kenyans employed by the UN. So for Kenyans, the local authority, the local jurisdiction applies. So corporations can sue and be sued in their own names, and they're liable to actions in tort. Trade unions, actions against them are limited, and no action shall be brought against trade union for torts. That is in the Trade Unions Act, Cap 233, Section 23. So persons of unsound mind are generally liable unless intent is a necessary element, and their condition being they could not have formed such intent. So for aliens and non-citizen, that is people who do not their birth status is not in Kenya. They're not citizens by birth, by naturalization. So they're not they can sue and be sued. So judicial officers are protected from civil liability for any act done or ordered by them in the discharge of judicial functions. So where a judge or magistrate utters words which tend to reflect on a person's reputation or orders a person's property to be attached in satisfaction of a judgment, no action can be brought against them for trespass. This means when a judge or magistrate orders that whatever is on your land to be sold off to recover the debt, you can't sue them for trespass. So their liability is, they're protected from civil liability.